Hi class, I'm a little frozen. Okay. Hi class, I am so excited to be speaking with you right now. We are on week 4 of our course, and we are going to be talking about confidentiality, privileged communication, huge essential parts to our field. This is a big part of why people come to counseling is because of confidentiality. And so we want to make sure clients have these rights and that they feel secured. There is a time when we breach confidentiality and it has to do with safety, right? And so we're going to talk about the difference between confidentiality, privileged communication, and privacy. So now, this sometimes can be difficult to understand. This information is something you will go over and over again when you are working with clients, when you're at your practicum sites. But confidentiality is rooted in the client's right to privacy, confidentiality at the core of effective therapy. It is the counselor's ethical duty to protect private client communication. Okay, privileged. So privileged communication is a legal concept that generally bars the disclosure of confidential communication in a legal proceeding. So for example, when minors come to therapy, for example, a child under 12 comes to therapy and parents are like, I want their records. We can claim privilege, meaning we're going to hold on to that information, and meaning the parents are going to have to take it a step further if they want that information. Now, you as a clinician can determine if you think it's beneficial for the client for sharing records. It may not be beneficial depending on how the parents are, how they behave, all the things. So you claim privilege on behalf of the client in order to preserve their information and their confidentiality. Now, if it gets taken a step further and a subpoena is ordered or things of that nature, then privilege, you could still try to claim privilege, but then it gets a little harder and the law gets involved and things of that nature. But initially, you have a right to claim privilege on behalf of your client to protect their confidentiality, to protect the child. Especially, sometimes things get used in a type of way with custody, and it can get very messy, very sticky. So there are those kinds of situations. Now, privacy is the constitutional right of individuals to be left alone and to control their personal information. And so, confidentiality, there's a 6-step practice model protecting confidentiality. So preparation, tell clients the truth, make sure we're getting informed consents. All this should be part of the paperwork that you give clients before session starts. That should all be signed. Respond ethically and legally for demands of disclosure, like kind of what I was discussing with wanting records. Avoid preventable breaches of confidentiality. Remember, out in public, we don't acknowledge our clients. Our clients can come and talk to us, but we're not going to acknowledge them because then again, how do you know this person? And talk about confidentiality. It's important that you explain what confidentiality means from the get-go. Like, you start your first session. For example, when I start my first sessions with people, like, hi, my name is Tony Howdergy. I'm a licensed marriage and family therapist. I'm a mandated reporter. So if you're to tell me harm to self, others, elder abuse, child abuse, I have to report. Otherwise, everything stays in the confines of this room. If you are an associate or a trainee, you're going to talk about how you share cases in practicum, and it stays under the umbrella of the facility. You ask them if they have questions about confidentiality. This is the reality. Most people get documents and records, documents to sign, and they don't sign them. I mean, how many things do you sign your name to that you never read the fine print, right? A lot of things. And so people don't really understand HIPAA. They don't understand confidentiality, what that means. And so it's your job to explain it to the best of your ability. You don't need to stay on it forever. But you do have to cover it before you get started, because if your client, we're going to talk about limits right now, but if your client brings up something that has to do with the limits of confidentiality, they could feel like a breach of trust. However, you are held to a legal standard that you are required to report and breach confidentiality. And they need to know what those things are so they can choose to share or choose not to share. It's up to them. So, the limits of confidentiality. So when a clerical assistant handles confidential information, so your facility might have, clerical worker, secretary, admin, someone who takes care of files and records. The consultation, so like we talked about supervision, things of that nature. The client has given consent for you to give like a release of information, to share things, harm to self or others, gonna commit a crime. There could be abuse or neglect, like we talked about, or an adult that's being abused or neglected. And then, of course, court orders where you are forced to release information. Okay, so it's important that you go over those limits prior to therapy really getting going, because people might choose to not tell you things, and that's within their right. So telecommunication, we got email, we got text messages, we have all the different things like Zoom, Google Meet. I have a platform I use with Simple Practice, smartphones, telephones, voicemails, how we leave messages on voicemails. So when you're leaving a voicemail, you have to be conscientious. Like maybe not everyone in the household knows that the client is in therapy, so be conscientious with that. Now, nowadays, like, there's not really home phones anymore. Not to say there's not in some cases, but, people could leave their work number. People could leave maybe a home phone number. If it's their personal cell phone, the voicemail usually goes straight to them. But you want to be mindful of how you're wording things, what you're asking for over the phone. So we want to make sure we're being mindful of confidentiality when we're leaving messages and things of that nature. How can we avoid those? Sometimes asking a client, is this the best place? Can I leave a message here? Those are good questions to ask. Because again, we don't know who's going to be listening to them. If we're talking on a phone, making sure about making them be in a private place. I've had clients, again, with technology now and how common, virtual therapy is. I mean, it's a whole way you can practice, right? You can have a whole therapeutic practice virtually. I have clinicians that just work virtually. It's very common. However, making sure your clients is in a private place is really important. I've had clients try to do sessions in a restaurant, in very non-private, non-appropriate places. It's very frustrating. And so you need to make sure they're in a private place, right? In a place where they can talk and not others are listening. I had one situation, this was early on in COVID, where the person started whispering because the person behind them was listening. I mean, it's just things that would not happen if we were in my office, right? When we're in my office, I have the door shut, sound screen on, like we're not worried about random people interrupting. But when someone's at home, even me at home, I could have my children interrupt. Like there's just more options for interruptions. So being clear about that, because we're really trying to protect confidentiality, even in a virtual setting. It's really important. We want the person to feel totally comfortable to share whatever they want. We even want them to feel like they can share whatever they want in their home. So if they're concerned about who's there, who's listening. I have some clients who wear AirPods, so I am not heard. They just talk, but I'm not heard, so they can't hear the questions that are being asked, things of that nature. You just want to make sure they're in a comfortable place that's safe and private, even in a virtual session, okay? Because again, a lot of the therapeutic experience is about being private and is about sharing things that you don't want other people to know. So if you're in an environment that doesn't allow that, you're going to have this sense of like not being completely honest still, because they don't feel like they can share. So just things to be mindful of. So HIPAA stands for the Health Insurance Portability and Accountability Act. It was established in 1996, and it promotes like a standardization of insurance information. It gives clients more rights over their personal information. You have HIPAA also with your medical records, like you go see the doctor or whatever. So it's trying how the information is transmitted through even electronic means. It's just a way to protect your information. So if you submit claims electronically, which I know I do, so you got to be mindful of privacy acts, electronic transactions, security requirements, all those things. There have been data breaches before, so you have to be conscientious of those and try to be on platforms that protect information for HIPAA and for the greater good of all your clients. These are things that we have to be mindful of. Okay. Duty to warn and protect, huge. I remember reading a book when I was in your shoes about a girl who ended up getting killed due to like the therapist. Not that it's the therapist's fault per se, but like when we're talking about warning people about somebody to be a harm to themselves, and then it goes to like court and it gets really messy. And probably we are in one of the most litigious states where people can sue for pretty much anything, really. So we have to be mindful of what we do. So duty to warn and protect. So it's balancing client confidentiality and protecting the public is more ethical and challenge that mental health professionals must assess in considering these competing interests, right? So like our client could say, I want to hurt somebody. And so there is still this need of like, I need to protect their information, right? Because we're like, I'm trying not to be liable for breaching confidentiality, but at the same time, there is this whole component of the greater good, right? So counselors must exercise this skill to identify clients who are likely to do physical harm to third parties, protect third parties from clients judged potential to be dangerous, and treat those clients who are dangerous. So we're juggling all parts, right? Like we have to treat our client, we have to potentially protect the public and protect the public from harm and what that looks like. And so this can be very tricky. I will say in all my years, like this hasn't come up a ton. Granted, our clientele is probably more on the average side, but whereas if you have maybe more severe chronically mentally ill people you're working with, this kind of topic might come up a little bit more. But it is something we all have to be aware of. And some of these massive shootings or things of this nature, some of these people have been under therapeutic care. And so you never want to be the therapist who's on the other side of that, right? Like I don't want to be. And I give all therapists the benefit of the doubt. Maybe the person never discussed wanting to harm somebody else. I mean, who knows? But it is a lot. I mean, we hold a lot of pressure and like responsibility in what we sit and what we do. It's a big responsibility, and it's not something to be taken lightly. So the duty to protect from dangerous acts or of violence is against again a practitioner's duty and can be neglectful if we don't do it right. If we don't make an adequate assessment, failing to warn victims, failing to commit dangerous individuals, like meaning 5150, put them on hold, prematurely discharging a dangerous client from a hospital, if you work in a more inpatient type setting. Tarasoff is one of the big cases that's very famous. There's a Bradley case. There's a few other cases where unfortunately the outcomes of these situations were not good. So dealing with dangerous clients, risk management guidelines with duty to warn and protect. So consult with colleagues or a supervisor, consult. Two, I want to say if you're in a room with someone who is dangerous, like you aren't to put yourself in harm's way for your client in a sense. So if you're feeling threatened, unsafe, know your office's policies and procedures. And I would make sure that you're handling things in a way that your office recommends. Like in my office, we have panic buttons in case of an emergency. Know what you're to do. Usually very stereotypically, a therapist always is the one that can access the door most easily so you can get out of a room. I'm not wanting you to stay in a room with an unsafe person. So please know all those protocols. And I'm not trying to scare you or again, like I have not myself even been in these situations, and I've been practicing now for 21 years. However, they can happen. And depending on the kind of situations you plan to work in, they could happen more often for you than for others. So if you're ever uncertain of what to do, consult with an attorney. I love CAMFT. That's California Marriage and Family Therapist. They have access to an attorney that you can call. They can't be your legal counsel, but they can give you legal advice. Know your state, for those of you that be LPCCs and practicing somewhere else, know the laws of your state. Know prior medical and behavioral information about your clients, and then know access to weapons, their homicidal ideation, intention, and if there's someone specifically involved or identified, how we can warn or help that person. Dealing with dangerous people. In case of immediate threat by a client, do not hesitate to take steps to prevent harm to yourself. Like I said, protect yourself first. Make referrals, maybe refer to emergency room temporarily until they can get into an inpatient center. Again, consider all appropriate steps and their consequences. Know and follow the policy of your institution. And document the people you consult, all actions you take, those you reject, and the rationale behind each of your decisions. This is when documentation is huge. Document. Okay. Because again, you have to justify why you've made whatever decisions you made. And if this comes up in a court situation, you need to make sure that you can prove why you decided to do what you did. Okay, implications for in a school setting. School personnel have a duty to protect students from harm. School personnel may need to act on student reports of their peers, and school officials may be held accountable if students' writing assignments contain evidence or premeditated violence. A lot of schools have a system called GoGuardian. I think Corona Norco uses it. I know Riverside uses it. It can be a bit annoying, but it flags even search engines that students look up. And this helps with harm to self, harm to others. It just will bring it up. And then there's this the school counselor will then approach the student, talk through what they saw them looking up and things of that nature as a way to be a preventative measure to catch things. I know of a client recently where they posted something that looked like a harm to self on Instagram. The FBI showed up at parents' house. I mean, there's a lot of things trying to flag these things to catch them before they become something detrimental or terrible, right? And so, searching, like things that people are searching on the internet can be a sign, so on and so forth. Okay. So when it comes to a suicidal person, we must, again, evaluate. So we're harm to self. Do they have means? Do they have access? Do they have a plan? You want to talk to your client about all these things, right? And then go from there as far as what your legal responsibility is. So make sure there's a reasonable assessment, professional consultation probably. What are your referrals? And again, make sure that you're documenting appropriately. You might even take a person, might even like release them to somebody else's care, like meaning if they're a minor, you might have their parent come pick them up if they drove themselves. If they're an adult, making sure a safe person is involved in checking in on them and helping them get to maybe the referral source you had. Now, there's a difference between being actively suicidal and maybe having suicidal ideation. Unfortunately, suicidal ideation is very common. Now, stuff can be said very flippantly. We are not judge and jury. Our job is to, again, evaluate. So we want to see if there's self-injury. Will the person most likely deal with ethical dilemmas regarding safety and duty to warn and protect? Are they cutting? Are they doing things like that to harm themselves? Those are the things we want to evaluate to see like where they're at. They may not be the severity at all of needing to be inpatient or intensive outpatient. Some people just struggle with having thoughts of wanting to harm themselves. They maybe have no active plan or even active means of doing so, but it's just a thought that comes to their head. That will happen often, and we don't necessarily always need to jump to, okay, I got a 5150U, but let's talk through how we can work through those thoughts, how we can reduce those thoughts, things of that nature. And this, unfortunately, will come up quite a bit. And so we got to take it seriously, though, like, because, again, we're talking about life and death, something to be taken very seriously. So when assessing, we take direct verbal warning seriously, pay attention to previous suicide attempts, identify if they're suffering with depression, things of that nature, be aware of hopelessness, helplessness, level of impulsivity. Can they problem solve? Do we have a lot of stressors? Is there any sort of loss or separation? Are there a lot of panic attacks? Has there been any sort of recent diagnosis or terminal health condition? Do they have a plan? Do they have a history of alcohol or drug abuse? Are they giving things away, finalizing affairs? Those are all signs. Revising their will. Have they ever had psychiatric treatment? Do they have access to a weapon? Can the client, does the client have any sort of support system? Is there any people who they rely on, that they talk to, that they have as a friend? Has suicide been something that's happened in the family? And do they have a plan where they just want to die? Things like that nature. There's the Columbia. That's a good assessment that anybody can do. You don't have to be a professional to use the Columbia. A lot of institutions, hospitals, things of that nature use that assessment to assess for suicidal ideation. But again, super, super important to make sure you're assessing correctly and documenting appropriately. This is where being on top of your notes is super important, because again, when these situations arise and if anything gets subpoenaed, you want to make sure you've been documenting appropriately and been documenting what you've been doing in assessing and treating this type of client. And again, protecting those that can't protect themselves. So children, dependent adults, mandatory, mandated reporting. And it's important that you know the process and procedure on how your agency wants to do that. There's a number. Most CPS workers, Department of Child Protective Service workers I've dealt with have been very kind and nice. They can help you fill out the form. I would document that you've done some, or document that they're saying they won't take a report. So at least you can say, I tried, they won't take a report. I would document when you called, all those things. But that's what you'll do in those situations. Now, you can choose to tell your client that you reported. Oftentimes I say honesty is the best policy. Reason being, they're going to know if I'm the only person that they told that you are going to report. However, there could be circumstances where if you tell the parent, let's say that you're reporting abuse, if the abuse is happening at home, that could cause there to be a safety issue to the child. So you want to take those things into consideration. When we're looking at elderly people and dependent abuse, we're looking at financial exploitation, abandonment, on top of the regular neglect, physical or emotional abuse, sexual abuse, or physical abuse. Okay. And when we're talking about dependent adults, that even could be someone who's developmentally delayed. It's not just elders. It could be people who are dependent on somebody else for their survival, and there could be abuse. I hope all this information was helpful. I kind of ran through it like quickly, but this is all essential information that you will give your clients from the get-go, and ways that you're going to have to deal with people who pose a threat to not only themselves, but to potentially somebody else. Have a good day.